President of the Law Society, CM, my good friend, distinguished guests, ladies and gentlemen, good afternoon. It gives me great pleasure to welcome you to Justice Place for the later half of this wonderful event organized by the In-House Lawyers Committee of the Law Society. Now, holding this annual conference in the Justice Place, which is the headquarters of the Department of Justice, is symbolic. Because as a matter of fact, the Department of Justice is the largest employer of in-house counsel in Hong Kong. Now, speaking for myself, when I prepared the speech, it occurred to me that I have just become an in-house lawyer for a little over than 2 months as a Secretary for Justice. Because most of you would know that I have been practicing as a barrister for almost 3 decades. Now, so I'm new to this job and I'm still getting used to this new role. So any tips and tricks from my friends who are in-house counsel will be most welcome. Now, the theme for this year is in-house lawyers being corporate connector. Now, I'm sure that you are well aware of your important role within your respective companies or organizations acting as such corporate connectors who serve to perhaps enhance corporate governance and compliance, avoid dispute, and handle dispute if they do arise. But what I wish to say is that what you must overlook is your important role in the context of the Hong Kong legal community, and indeed Hong Kong as a whole. Back in 2016, Mr. Justice Robert Tang, PJ, as he then was, remarked that in-house lawyers are a substantial force in the legal community in Hong Kong. This is undoubtedly an utmost important and accurate statement. Now, the way I construe this statement is that in-house lawyers, because of the peculiar nature of their jobs, can very often do what other private practitioners cannot or struggle very hard to do. Say, for example, they have the power to connect their employees' businesses to a particular jurisdiction. You may take part in deciding where a business should be headquartered, what should be the governing law of the contracts or the relevant contracts to which your employers are parties, and where and how any dispute arising out of these contracts should be resolved. And I still remember that in a very famous Hollywood movie, a certain masked hero had said, "With great power comes great responsibility." Now, not only do you have all these very potent and important powers, I would venture to suggest that you, as member of the Hong Kong legal community, also have a very serious responsibility. What I have in mind is the responsibility to connect business and matters under your sphere of influence with the jurisdiction that we are most familiar with, namely Hong Kong. So, for example, I would urge you to consider seriously to advise your employers to choose Hong Kong law as the governing law of the relevant contracts, and Hong Kong to be the jurisdiction where dispute should be resolved irrespective of how. In addition, when advising your employers, which outside law firms or lawyers, including solicitors and counsel, should be engaged, I would also encourage you to seriously consider Hong Kong local law firms and lawyers, as you will no doubt agree with me that many, in fact most Hong Kong lawyers are immensely talented and no less competent than their foreign counterparts. Hong Kong is already an international legal service and dispute resolution hub because of our common law system and our diverse pool of legal talents, to name a few our unique advantages. But a very unique and perhaps the most unique advantages enjoyed by Hong Kong is the substantial opportunities under or created because of the principle of one country, two systems. President Xi, in his recent speech, made on the 1st of July, marking the 25th anniversary of the establishment of the Hong Kong Special Administrative Region, made it crystal clear that the principle of one country, two systems is a long-term policy that must be adhered to and will certainly go beyond 2047. This means that Hong Kong will remain as the only common law jurisdiction in our country, China, bring along with it fundamental features such as the rule of law and the independence of the judiciary. The National 14th Five-Year Plan, also mentioned by President Xi in his speech, explicitly support Hong Kong's development into a center for international legal and dispute resolution services in the Asia-Pacific region. This, coupled with other national development policies, such as the Greater Bay Area Initiative and the Belt and Road Initiative, make Hong Kong truly a place full of opportunities for the business and legal communities. Now, Hong Kong must seize the opportunities created by these national development plans proactively. Among other things, it needs to enhance the cooperation and collaboration between the two legal systems in the mainland and Hong Kong, respectively. Now, in this respect, Hong Kong has already entered into various legal assistance arrangements with the mainland on various matters. And I would like to take this opportunity to highlight a few which may be of particular relevance to your work as in-house lawyers. The first is a bundle of arrangements concerning arbitration, which provide a comprehensive regime for recognition and enforcement of arbitral awards between the two jurisdictions, and also allow parties to arbitral proceedings seated in Hong Kong to apply to a mainland court for interim measures. These arrangements are complemented by recent legislative amendments to the arbitration regime in Hong Kong, which permits agreements using outcome-related fee structure for arbitration, HKSAR, I think that's the abbreviation, and also third-party funding for arbitration. And these measures were previously prohibited under, for example, the common law doctrines on maintenance and champerty. The second is a bundle of arrangement with the mainland concerning reciprocal enforcement and recognition of judgment, covering a wide range of commercial and civil matters, including intellectual property rights. Now, although the arrangement concerning a previous choice of court agreement is already enforced for a number of years, the most recent bill to implement the latest arrangement concerning recognition and enforcement of civil and commercial matters is a very important development. It is currently at the bill committee stage in the Legislative Council. And in fact, I'm very pleased to say that we have already completed that part of the legislative procedure, and we are waiting for the resumption of the second reading of the bill. I hope and expect that the ordinance will be formally enacted very soon before the end of this year. So once enacted, the new arrangement, which will become part of our Hong Kong law, will offer substantial improvement to the previous regime. For example, it will include the removal of the requirement of an exclusive jurisdiction clause as a precondition for recognition and enforcement of the judgment. Lastly, I wish to mention the record of meeting concerning mutual recognition of and assistance to insolvency proceedings, which was signed in May 2021 with the mainland, which established a new mechanism which allows Hong Kong liquidators and administrators to apply to mainland courts in 3 areas. having regard to the fact that it's a pilot scheme. The 3 pilot areas are Shanghai, Xiamen, and Shenzhen, for the recognition of insolvency and debt restructuring proceedings in Hong Kong. Now, in practice, this means that assistance may be granted in relation to, for example, the taking over of debtor's property and investigation in the financial position of a debtor who is subject to insolvency or similar proceedings. Now, there's no question that this arrangement will provide better protection to safeguard the interests of the creditors. And I sincerely hope that this pilot scheme may extend to other cities in the mainland in the near future. I would also like to take this opportunity to highlight to you the initiative for wholly owned Hong Kong enterprises to be allowed to adopt Hong Kong law and choose arbitration to be seated in Hong Kong in their contracts. I think we have a very easy term, a simple term for that. It's 港資港法港仲裁, which are already in place in part of the Greater Bay Area. Now, this measure will create more options for companies and business enterprises seeking to grasp the opportunities in the Greater Bay Area. We are actively seeking to further liberalize the measure in this respect and hope to expand this measure to the whole of the Greater Bay Area, once again in the near future. Ladies and gentlemen, I'm confident that with the support of the Central People's Government, there will be more opportunities, benefits, and advantages to come for Hong Kong business and enterprises and indeed the legal community. My department, the Department of Justice, shall continue to strive for closer cooperation with the mainland authorities with the view to provide further benefits and advantages to businesses and the business community and the legal community in the Greater Bay Area and beyond. I would encourage you to capitalize on Hong Kong's unique advantage. Namely, while it's a part of China, it has a well-renowned common law system with a very long history of success. Now, with this remark, I hope you will enjoy the rest of today's conference and with more insightful discussion of common interests. Thank you very much.